The call came on a Tuesday morning in October, and it came from a woman named Patricia Holloway, who had lived 3 houses down from my mother's place on Fenwick Drive for the better part of 22 years. Patricia was not the kind of woman who called unless she had something specific to say. She was in her late 60s, a retired postal worker, and she paid attention to the neighborhood the way only people who have spent their whole lives in one place tend to do. She noticed when trash cans were out too long. She noticed when lights were left on overnight. She noticed, apparently, when a 14-foot box truck with the logo of a regional moving company backed into the driveway of a house that was supposed to be sitting empty. I was in my apartment in Raleigh when the phone rang. I had been at the kitchen table with a cup of coffee and a contractor invoice that I had been meaning to review since the previous Thursday, and I remember looking at the screen for a moment before I answered because I did not immediately recognize the number. She introduced herself, and I remembered her instantly, the woman who used to bring my mother a paper bag of tomatoes from her garden every August without fail. I told her I remembered her and asked what was going on. She said there were people at the house, not just 1 or 2 people. She described a full team. A moving company crew was unloading furniture from the truck. 2 men in button-down shirts were standing on the lawn with what looked like an architect's measuring wheel. A woman in a blazer had been walking in and out of the front door since about 8 that morning. Patricia said she had waited 2 hours before she called me because she assumed maybe I had arranged something and forgotten to mention it to her. But then she saw the name on the side of the moving truck, and it wasn't any company she had heard me mention before. And the men with the measuring wheel didn't look like friends or family. And something about all of it felt mom enough that she decided to make the call. I told her thank you, told her I would handle it, and I set down the phone and sat completely still for about 45 seconds. My mother's name was Eleanor Ruth Carver. She passed away 18 months before that Tuesday morning in April, after a short illness that moved faster than any of us expected. She had owned the house on Fenwick Drive outright, no mortgage, no liens, property taxes always current. She had lived in that house for 31 years. She raised my sister Valerie and me in it. When she passed, her will went to probate in Mecklenburg County, and the estate was administered over the course of about 6 months. The will split her estate evenly between Valerie and me, 50% to each. There was some personal property, there was a small bank account, and there was the house. The probate court finalized the distribution 14 months before Patricia's call. Both Valerie and I received deeds conveying our respective shares of the real property. I had my deed. It was in a manila envelope in the top drawer of my filing cabinet. It had a recording stamp on it from the Mecklenburg County Register of Deeds. It existed as a matter of public record. I did not panic. I want to be clear about that because the rest of this story is about what I did rather than how I felt. And the distinction matters. I picked up the phone again and called Valerie. She answered on the 3rd ring. Her voice was level. She said hello, the way she always said hello, slightly high in pitch, slightly rushed, the tone of someone who has caller ID and already knows who it is. I told her Patricia Holloway had called me. I told her what Patricia had described. I asked her what was happening at the house on Fenwick Drive. There was a pause, not a long pause, maybe 3 seconds. Then she said she had been meaning to talk to me about this. She said the situation with the house had been getting complicated, and she had made a decision as executor. She said the estate had carried maintenance costs that she had been covering herself, and she had decided it was better to sell the property outright than to continue holding it. She said the process was already complete. I asked her to repeat that last part. She said the sale had closed. She said it had closed 17 days ago. I asked her who authorized the sale of my 50% interest in that property. She said she was the executor. She said she had the authority to manage estate assets. She said she had handled everything legally, and that if I had questions I could look at the paperwork. I asked her where my half of the proceeds were. She said the estate expenses had to be settled first. She said there had been deferred maintenance, carrying costs, and legal fees associated with the administration that ate into the distributions. She said there might be a balance remaining, and she would send me an accounting. I said I would be in touch, and I ended the call. I sat back down at the kitchen table. I did not raise my voice during that conversation. I did not accuse her of anything. I asked questions, I listened to the answers, and I filed everything she said in the same part of my mind where I keep things that require verification. Because the specific things she said did not add up in a way that should satisfy anyone who has ever held a recorded deed in their own name. I was not an heir waiting for the estate to settle. The estate had already settled, the probate was closed, The court had issued a final order of distribution, and that order had been recorded, and as a result of that recording, I held a 50% undivided interest in the property at 4417 Fenwick Drive as a matter of fee simple ownership. I was not a creditor of the estate, I was not a beneficiary waiting for a check, I was an owner of record. Whatever Valerie had done, she had not sold her half of the house, she had sold all of it. I opened my laptop and navigated to the Mecklenburg County Register of Deeds online portal. I want to explain something about this system for people who have never used it, because it becomes important later. Every document that gets recorded with a county register of deeds office becomes part of the permanent public record of that county. Deeds, liens, mortgages, assignments, releases, affidavits. Every one of them is indexed by grantor and grantee name, and by the property's parcel identification number. When a property changes hands, every step in that chain of title is visible to anyone who looks. Title companies examine these records before every closing. Lenders require it. Attorneys conduct what are called title searches that trace ownership back decades to ensure that the person selling the property actually has the legal authority and ownership interest to do so. I typed in the parcel number for 4417 Fenwick Drive. The number was on my deed, and I had it memorized. The search returned a list of recorded instruments in reverse chronological order. The most recent entry was a special warranty deed recorded 23 days before that Tuesday morning. The grantor was listed as Valerie Carver, described in the instrument as sole heir and personal representative of the estate of Eleanor Ruth Carver. The grantee was listed as Dean Property Holdings LLC. The consideration stated was $412,000. I scrolled down the list of instruments. Below the special warranty deed was a document I had never seen before. It was an affidavit of heirship, recorded 2 days before the deed, approximately 25 days before Patricia's call. The affiant was Valerie Carver. The affidavit declared, under oath, that Valerie Carver was the sole surviving heir of Eleanor Ruth Carver, and that no other persons held any legal interest in the property at 4417 Fenwick Drive. I kept scrolling. Below the affidavit were the instruments I recognized. There was the final order of distribution from the Mecklenburg County Probate Court, recorded 15 months earlier. There was my deed, recorded the same week as the order, conveying a 50% undivided interest in the property to me. There was Valerie's deed, recorded the same week, conveying a 50% undivided interest in her. Both deeds were there, both were recorded, both were part of the public chain of title. I printed all of it, every instrument. I printed the affidavit of heirship. I printed the special warranty deed to Dean Property Holdings LLC. I printed the probate order. I printed my deed. I printed Valerie's deed. I put them in order by recording date, put them in a folder, and drove to Charlotte. The drive from Raleigh to Charlotte takes approximately 2 hours and 40 minutes on a good day. I made it in 2 hours and 28 minutes. I am not going to describe what I thought about during that drive, because this story is not about thoughts. It is about what happened when I arrived and what I did about it. I went to the property first. Patricia had called me around 9 in the morning, and by the time I pulled onto Fenwick Drive, it was just past noon. The box truck was gone. The men with the measuring wheel were gone. But there was a late-model silver sedan parked in the driveway, and through the front window I could see that someone had already moved furniture inside. The living room, visible through the glass, contained items that had not been there the last time I stood in that house. Boxes stacked along the wall. A couch in a style my mother would never have chosen. Someone was in the process of moving in. I did not go to the door. I noted the sedan's plate number in the notes application on my phone. Then I drove to the Mecklenburg County Register of Deeds office on East 4th Street. The woman at the counter was patient and thorough. I gave her the parcel number and asked for a complete certified copy of the chain of title for the property. She told me it would take about 20 minutes to pull and certify the copies. I sat in a plastic chair along the wall and I waited. When she brought them back to me, there were 11 instruments total. She had pulled everything. I reviewed them in order at a table near the window. The chain read cleanly up through the probate. Eleanor Carver had owned the property free and clear since 1993. She had never mortgaged it. There were no liens. The property taxes were current through the prior year. The probate order was there. My deed was there. Valerie's deed was there. Then the affidavit of heirship. And then the special warranty deed to Dean Property Holdings. I looked at the notarization block on the affidavit of heirship. The notary's name was printed beneath the signature line, Teresa Boggs. There was a commission number and a commission expiration date. I wrote down both numbers. Then I drove to the office of an attorney. I had not retained an attorney before that afternoon. I had not needed one since the probate, and the attorney who handled the probate estate was my mother's attorney, a man named Gerald Park, who had retired and closed his practice 6 weeks after the estate was finalized. I had not replaced him because I had not anticipated needing to. What I did have was a contact in Charlotte, a man named Carl Whitfield, who had been 2 years ahead of me in college and who had gone on to build a real estate and civil litigation practice. We were not close in the way that people who talk regularly are close, but we had stayed in contact, and I knew his work, and when I called him from the parking lot outside the Register of Deeds office, he answered his own phone. I told him what had happened in about 6 minutes, precisely and without embellishment. I told him what I had found in the public record. I told him I had the certified copies in my hand. He asked me one question: was the probate in Mecklenburg County? I told him yes. He told me to come to his office at 2 o'clock. His office was in a mid-rise on South Tryon Street. He had 2 associates and a paralegal named Donna, who I later came to understand was the actual organizational engine of the entire operation. I arrived at 5 minutes before 2. Whitfield met me in the conference room, and we spent 45 minutes going through the documents. He laid them out in sequence on the table. He did not say anything for the first several minutes. He read everything. His reading was methodical and unhurried in the way that people who are paid to be precise tend to read important documents. When he finished, he stacked them neatly and set them to his left and looked at me. He said the situation was straightforward in its facts and serious in its legal dimensions. He explained what I already understood, but articulated it with the precision that matters when you are preparing to enter a formal legal proceeding. My deed, recorded 15 months prior, conveyed fee simple title to 50% of the property. That recordation constituted constructive notice to the entire world, including any subsequent purchaser. Under the recording statutes of North Carolina, no subsequent deed purporting to convey an interest in that property could legally extinguish my recorded interest, unless I was a party to that conveyance, and had signed it, or unless a court order specifically directed otherwise. I had signed nothing, no court had ordered otherwise. The special warranty deed Valerie had executed to deem property holdings purported to convey 100% of the property. It could not legally convey what she did not own. She owned 50%. She could legally convey only 50%, and only with proper authority, and even that was a matter that required scrutiny given the procedural irregularities. He asked me about the affidavit of heirship. He looked at it closely. He read the notarization block. I asked me if I knew Teresa Boggs. I told him I did not. I told him the name meant nothing to me, but that I had noted her commission number and expiration date from the document. He asked Donna to call the North Carolina Secretary of State's office and verify the commission status of the notary whose commission number appeared on that affidavit. Donna wrote down the number and left the room. Whitfield then told me what we needed to do immediately, before anything else. He said the first and most urgent step was to file a notice of lease pendens in the Mecklenburg County Register of Deeds office against the property. A lis pendens is a recorded notice that an action affecting the title to a specific property is pending in a court of law. Once recorded, it becomes part of the chain of title, and serves as constructive notice to any person who subsequently deals with that property that there is a legal dispute. It effectively clouds the title. Anyone conducting a title search on the property, any lender, any title company, any subsequent buyer, would see it immediately. It would not transfer the property back to me on its own, but it would prevent the situation from getting worse while the legal process proceeded. It would stop the clock on Dean Property Holdings' ability to refinance, borrow against the property, or resell it cleanly. He said we needed to file the lis pendens that afternoon. Then we needed to file a complaint for quiet title, fraud, constructive fraud, breach of fiduciary duty, and unjust enrichment. He said the quiet title action was the core of it. A quiet title action asks the court to determine and declare the true state of ownership of a piece of real property, and to issue an order that resolves any conflicting claims. Given the documentation I had, he said, the legal basis was strong. Donna came back into the room. She set a printed page in front of Whitfield without saying anything and returned to her desk. Whitfield read it. Then he turned it so it was facing me. The notary commission for Teresa Boggs, commission number as recorded on the affidavit, had expired 8 months before the affidavit was signed and notarized. Her commission had lapsed. She had no authority to act as a notary on the date that affidavit was executed. The document that Valerie had used to declare herself the sole heir of the estate, the foundation of her claimed authority to sell the entire property, had been notarized by someone who had no legal authority to notarize it. In North Carolina, a document notarized by a person whose commission has expired is not a properly acknowledged instrument. It cannot be legally recorded. It cannot serve as a legal foundation for anything. It had been recorded anyway. The Register of Deeds had accepted it because the commission number was printed correctly, and the seal was physically present, and the office does not individually verify commission status at the moment of recording. But the defect was real, and it was permanent. It was in the record and it was provable, and once we established it in a court proceeding, the affidavit would be treated as void. Whitfield said we would add a count challenging the validity of the affidavit specifically. He said the combination of the fraudulent content of the affidavit, which falsely claimed I had no interest in the property, and the defective notarization would matter significantly when we got before a judge. We spent the next 2 hours drafting and finalizing the documents. The lis pendens was a single page. The complaint was 22 pages by the time we finished, organized into factual allegations, legal counts, and a prayer for relief that asked the court to declare the special warranty deed to Dean Property Holdings void. As to my 50% interest, to impose a constructive trust on the sale proceeds attributable to my interest, to hold Valerie liable for fraud and breach of fiduciary duty, and to award attorney's fees and costs. Whitfield filed both documents with the court before 5 o'clock. The lis pendens was walked over to the Register of Deeds by Donna personally and recorded that same afternoon. By the time Valerie sat down to dinner that Tuesday evening, the chain of title to 4417 Fenwick Drive had a pending legal action attached to it, recorded in the public record, and anyone who pulled that chain of title for any reason would see it within seconds. I checked into a hotel in Charlotte that night. I did not call Valerie. The following morning I went to the property. This time I knocked on the door. The woman who answered was in her early 40s, well dressed in the way that people who work in commercial real estate tend to dress on their days off. She had a phone in her hand and looked at me, the way people look at an unscheduled interruption. I introduced myself by name. I told her my mother had owned this house, that I had a recorded 50% ownership interest in it, and that I had filed a legal action the previous afternoon challenging the validity of the transaction through which the property had been transferred to Dean Property Holdings. I told her she might want to contact whoever had facilitated the transaction on behalf of the company. Her expression changed in a specific way. It was not panic, it was the particular calculation of someone who handles enough real estate to understand what the words lis pendens mean in practical terms. She asked me if I had documentation. I handed her a copy of my recorded deed and a copy of the lis pendens filing. She took them without saying anything further, stepped back inside and closed the door. I found out later through Whitfield that she called Hargrove Title within the hour. Hargrove Title was the title company that had handled the closing for the Dean Property Holdings transaction. They had issued a title insurance policy to the buyer at closing. Title insurance exists precisely to protect buyers and lenders from defects in title that were not discovered during the closing process. When I filed the lis pendens and complaint, Hargrove Title became a party with significant financial exposure. They had certified a clean title. They had issued a policy. If the court ruled that the sale was void as to my interest, they would be liable under that policy. Whitfield received a call from Hargrove Title's outside counsel, a firm called Webb Donahue and Marsh, on Thursday morning, 2 days after we filed. They requested copies of all our documentation. Whitfield provided them with a cover letter that laid out our legal position concisely and without hostility. We did not need to be hostile. The documents did that work themselves. The court scheduled an initial hearing on our motion for an expedited order to preserve the status quo of the property for approximately 3 weeks out. That meant 3 weeks during which Dean Property Holdings was in possession of a property with a clouded title. Hargrove Title was sitting on a potential claim under their own policy, and Valerie was aware that a lawsuit naming her as defendant had been filed and served. Service of process on Valerie occurred on the Friday after we filed. She lived in Concord, about 15 miles from Charlotte. The process server reached her at her home at approximately 10:30 in the morning. I was in Raleigh by then, back at my apartment, working and waiting. Whitfield called me that Friday afternoon to confirm service. He said Valerie had not yet retained an attorney as of that morning, but that we should expect an appearance within the following week. He was right. An attorney named Clifford Haynes entered an appearance on Valerie's behalf 8 days after service. Whitfield pulled his background and told me Haynes was a general practice attorney in Concord, with some domestic and estate work in his history, but limited civil litigation experience. He was not a specialist. I want to note something here because it is relevant to how this story ends. At no point in any of this did I speak to Valerie directly after that first phone call on Tuesday morning. I had nothing to say to her that mattered outside of a courtroom. Everything that needed to be communicated between us would be communicated through filings, through discovery, through hearings, and through whatever decision the court ultimately made. Some people, when they find themselves in a situation like this one, feel the need to confront, to accuse out loud, to extract an admission or an apology through the force of an argument. That is understandable. It is also tactically useless. Every conversation I might have with Valerie was a conversation in which she could rehearse explanations, in which I could inadvertently disclose something about our legal strategy, in which emotion could override precision. The court did not care about conversations between siblings, it cared about records. What Whitfield told me in the first week that turned out to be important was this: the question of intent would matter less than the question of documentation. We did not need to prove that Valerie had deliberately set out to defraud me, though the evidence strongly suggested it. We needed to prove that the conveyance of 100% of the property was legally invalid as to my interest. That was provable on the face of the recorded documents alone. The additional counts, fraud, breach of fiduciary duty, required more, but even those were supported by the documentary record in ways that did not depend on Valerie's admission of any state of mind. The discovery process began. Whitfield issued a request for production of documents to Valerie through her attorney, within 2 weeks of the complaint being filed. The requests were specific and comprehensive. We asked for all communications between Valerie and any real estate agent, broker, or representative concerning the property. We asked for all communications between Valerie and Dean Property Holdings, or any of its representatives. We asked for all documents related to the affidavit of heirship, including any drafts, any communications with the notary Teresa Boggs, and any instructions or guidance received from anyone in connection with the preparation of that document. We asked for all documents related to the closing, including the settlement statement, the wire transfer records, and any distribution of proceeds. The responses came in stages. Some documents were produced promptly. Others were delayed with objections that Whitfield addressed methodically through meet and confer correspondence. The settlement statement from the Hargrove title closing was produced in the second round. It was a standard HUD-style statement showing the full transaction: sale price $412,000, credits, prorations, closing costs, and commissions. And at the bottom, the net proceeds to the seller, $368,420, wired in full to a single account, Valerie's account, not split, not held in escrow pending probate accounting, not subject to any deduction for the estate maintenance costs she had described on the phone. $368,000, net transferred in a single wire to Valerie Carver on the day of closing. My share of that, at 50% of the net proceeds after reasonable deductions, would have been approximately $160,000 to $170,000, depending on what legitimate expenses were attributed to the property. None of that money had come to me, none of it had been offered to me. Valerie had made no accounting, she had simply taken it. The wire transfer record also told us something else. It told us the exact date and time the funds were received. We cross-referenced that with the timeline of communications that Whitfield had assembled from Valerie's document production. What emerged was a sequence. Approximately 8 months before the closing, Valerie had been in contact with a real estate agent named Sandra Holt at a brokerage called Cornerstone Residential. The communications showed that Valerie had represented herself to Holt as the sole owner of the property. She had described the property as an estate sale, which it was in substance, but not in the legal sense she was implying, and she had told Holt that the probate was clean and that she had full authority to sell. Holt had listed the property on the multiple listing service at $395,000. The property had attracted several offers, and Dean Property Holdings had ultimately made an offer of $412,000. 3 months before the closing, this is the part that mattered most, Haynes filed a response to our complaint on Valerie's behalf that asserted several affirmative defenses. The defense that required the most attention was this. Haynes alleged that I had, prior to the sale, executed and delivered to Valerie a quitclaim deed conveying my interest in the property to her, and that this quitclaim deed constituted a valid voluntary relinquishment of my ownership interest, and that Valerie had therefore been the sole owner of the property at the time of the sale to Dean Property Holdings. He attached a document to the response as an exhibit. It purported to be a quitclaim deed signed by me, notarized, conveying my 50% interest to Valerie. The grantor line had my full legal name. The signature on the grantor line was a reasonable but imperfect facsimile of my signature. The notarization block contained the name and stamp of a notary I did not recognize and had never met. I called Whitfield the morning after I reviewed the response. I told him I had never signed that document. I told him I had never met the notary whose name appeared on it. I told him I had never been in the presence of a notary in connection with any instrument related to this property since the probate conveyance, and that the probate conveyance had been handled by Gerald Park's office, not by any notary whose name appeared in this new document. Whitfield told me to keep talking. I told him to look at the date on the document. The quitclaim deed that Haynes had attached to the response was dated 11 months before the closing. That placed it approximately 3 months after my mother passed away, and roughly 3 months before the probate estate was finalized and the distribution deeds were issued. Whitfield was quiet for about 4 seconds. Then he said, "I see it. A quitclaim deed conveys whatever interest the grantor has in a property at the time of conveyance. It is a limited form of deed, it makes no warranties, but it conveys the grantor's actual current interest. On the date the alleged quitclaim deed was signed, the probate had not yet been finalized. The distribution deed conveying my 50% interest to me had not yet been issued. The court's final order of distribution had not yet been entered. On the date of that alleged quitclaim deed, I did not have a deeded ownership interest in 4417 Fenwick Drive. I had a beneficial interest as an heir to my mother's estate, which is a different legal instrument with different legal characteristics. A quitclaim deed executed before the distribution of estate assets cannot convey those assets because the assets do not yet belong to the grantor at the time of execution. The chain of title on this property was established by court order and recorded deed 14 months before Patricia's call. Whatever interest I had before that order was formalized into title at the moment the probate court issued the distribution and the deeds were recorded. In other words, even if the alleged quitclaim deed had been signed by me, which it had not, and even if the notarization had been valid, which was doubtful given the pattern we had already seen, the document was legally ineffective because it predated the vesting of my title by 3 months. You cannot sign away property you do not yet own. A quitclaim deed conveys present interest. I had no recorded present interest on the date of that deed, therefore the deed conveyed nothing. We filed a supplemental memorandum in support of our quiet title motion within the week. The memorandum laid out the timeline with precision. It attached, as exhibits, the probate court's final order of distribution with its recorded date, my distribution deed with its recorded date, and a calendar showing the 11-month gap between the alleged quitclaim and the actual vesting of my title. It was supported by case law from North Carolina courts going back 40 years establishing the principle that a quitclaim deed cannot convey what the grantor does not possess at execution. We also raised the question of the quitclaim deed's authenticity directly. We moved for forensic examination of the document. Whitfield engaged a certified forensic document examiner named Dr. Raymond Tellez, whose practice was in Greensboro and who had testified as an expert in North Carolina courts in over 200 cases. Haynes objected to the examination on several grounds. The court overruled all of them. Dr. Tellez received the original document for examination. While we waited for those results, the deposition phase began. Whitfield deposed Valerie first. The deposition lasted 4 hours and 40 minutes. I was not present in the room, but I reviewed the transcript when it was produced. I am going to describe the relevant portions of it because they are the heart of what happened. Whitfield asked Valerie to explain her understanding of the ownership structure of 4417 Fenwick Drive following the finalization of the probate. She said she understood that she had been given the executor's authority to manage and dispose of estate assets. He asked her whether she had been aware that a distribution deed had been recorded, conveying 50% of the property to me. She said she had seen paperwork, but did not believe it meant what it appeared to mean. He asked her what she believed it meant. She said she believed the deed was a formality that didn't change the practical situation of the estate. She asked her to explain what she meant by practical situation. She said she meant that the house needed to be sold to resolve the estate costs. He asked her whether she had consulted an attorney before executing the affidavit of heirship or before executing the special warranty deed to deem property holdings. There was a pause. Haynes conferred with her quietly, then she said she had consulted with someone but did not recall the specifics. He asked for the name of anyone she had consulted with in connection with the preparation of the affidavit of heirship or the sale of the property. She said she did not recall. He asked whether she had ever seen before the filing of the list pendants and complaint, the recorded deed conveying a 50% interest to me. She said she may have seen something like that. He asked whether she had ever brought that deed to the attention of the listing agent, the title company, or Dean Property Holdings. She said no. He asked whether she had disclosed to Hargrove Title, at any point during the closing process, that a distribution deed had been recorded, conveying 50% of the property to someone other than herself. She said no. He asked whether she had disclosed my existence as a co-owner to the real estate agent Sandra Holt at any point during the listing process. She said no. He asked her to describe how the affidavit of heirship had been prepared. She said she had found a template online and filled it out herself. He asked about the notary Teresa Boggs. She said Teresa Boggs was a woman she knew from a previous employer who had been a notary. He asked whether she had verified that Boggs' commission was current at the time of notarization. She said she had not thought to do that. He asked whether Boggs had reviewed the content of the affidavit before notarizing it, or had simply witnessed the signature. Haynes objected to the characterization. The answer that followed was that Boggs had reviewed the document. He asked where the notarization had taken place. She said at a coffee shop. He asked whether any other witnesses had been present. She said she did not remember. He asked how the proceeds of the sale had been distributed. She said she had received the wire and had been planning to make distributions after resolving the estate accounting. He asked how much of the net proceeds she had distributed since the closing, to anyone in connection with the estate. She said she had not yet made distributions. He asked how many days had elapsed since the closing. She said she wasn't sure of the exact number. He said the exact number, based on the closing date reflected in the settlement statement, was 71 days. She said she had been planning to do the accounting. He placed the settlement statement in front of her and asked her to identify the account to which the wire had been sent. She identified it. He placed a bank statement in front of her, produced under subpoena to her financial institution, showing that account. He asked her to describe the transactions in that account in the 30 days following the closing wire. Haynes objected. He was overruled. The statement showed the wire arriving. It also showed, in the subsequent 3 weeks, transfers of varying amounts totaling approximately $220,000, moving to 2 different accounts. One of those accounts was identified in subsequent subpoena returns as a personal investment account Valerie had opened 18 months earlier. The other was a joint account she held with a person whose name I will not include here, for reasons unrelated to the legal proceedings. She had not been holding the money for estate accounting, she had been moving it. The deposition of Sandra Holt, the listing agent, followed Valerie's. Holt's deposition was shorter and significantly less comfortable for Valerie's position. Holt testified that Valerie had represented herself as the sole owner of the property at every stage of the listing and sale process. She testified that she had asked Valerie directly, at the initial listing appointment, whether there were any other parties with an interest in the property, and that Valerie had said no. She testified that she had been aware of another recorded owner. She would have required that person's signature on the listing agreement and the disclosure forms, and would have ensured the title company was informed before proceeding to closing. She testified that she had had no knowledge of my existence, of my recorded deed, or of the probate distribution until she received a call from Hargrove Title's counsel 3 weeks after the lis pendens was filed. The deposition of the Hargrove Title closing agent followed. She testified that the title search conducted prior to closing had identified the probate instruments in the chain of title and had noted the distribution deeds. She testified that her notes from the title examination reflected that she had flagged the distribution deeds as items requiring resolution and had communicated that flag to the transaction coordinator for the Dean Property Holdings purchase. She testified that she had then received a response from the transaction coordinator indicating that the matter had been resolved by the affidavit of heirship filed by the seller, and that she had accepted that representation without independently verifying the content of the affidavit against the distribution deeds already in the chain of title. That testimony was significant. It established that Hargrove Title had seen the distribution deeds, it had recognized the issue, and it had accepted Valerie's fraudulent affidavit as the resolution of that issue, without conducting the analysis that would have revealed the contradiction between the affidavit's claim and the recorded instruments. The Hargrove Title closing agent also testified, when asked about the notarization of the affidavit, that the title company did not, as a standard practice, verify notary commission currency on affidavits submitted to clear title issues. They relied on the face of the document. The commission number and seal were present. They proceeded. Dr. Tells's forensic examination report arrived 6 weeks after the depositions concluded. It was 12 pages, single-spaced, with 24 comparison exhibits attached. His methodology was thorough, and his conclusions were stated with precision appropriate to expert testimony. He examined the alleged quitclaim deed using a combination of handwriting analysis, ink chemistry analysis, and paper substrate testing. His findings on the handwriting were qualified. He could not definitively exclude that the signature was a forgery, but he identified 18 points of significant deviation from known exemplars of my signature that he had obtained through a comparison set. He described those deviations in the language of his discipline as suggesting that the signature was produced by someone who had studied, but not mastered the authentic signature's specific characteristics. More decisive was the ink analysis. The ink chemistry on the alleged quitclaim deed was inconsistent with the date printed on the document. The specific formulation of the ink used for the signature had not been in commercial distribution until approximately 14 months before the testing date, which was approximately 4 months after the date printed on the document. The document purported to be approximately 15 months old. The ink used to sign it could not have existed at the time it was allegedly signed. The document was not what it claimed to be. Whitfield filed the expert report with the court on a Thursday and requested an accelerated hearing date given the criminal implications of the findings. The court agreed to move the scheduled hearing forward. The hearing took place in Courtroom 4 of the Mecklenburg County Superior Court on a Wednesday morning in February. I was present. Valerie was present with Haynes. Webb, Donahue, and Marsh had entered an appearance on behalf of Hargrove Title as an interested party. A representative of Dean Property Holdings was in the gallery. The judge was the Honorable Patricia Wren, who had been on the Civil Division bench for 14 years. She was not a person who asked unnecessary questions or tolerated imprecision. She had read the file in advance. I could tell that from the way she looked at the parties when we were called to the bench, the look of someone who has already formed a preliminary view of the factual landscape and is present to refine it, rather than to discover it. Whitfield presented our case in 2 hours and 11 minutes. He walked the court through the chain of title chronologically, document by document. He presented the probate order. He presented my distribution deed. He presented the affidavit of heirship with the expired notary commission. He presented the special warranty deed to Dean Property Holdings. He presented the deposition excerpts. He presented the wire transfer records and the bank statements. He presented Dr. Tellez's forensic report and qualified Dr. Tellez as an expert witness in forensic document examination, which the court accepted after a brief voir dire. Dr. Tellez testified for 40 minutes. He spoke with the calm authority of someone who has explained his methodology many times to many judges and who has no investment in the outcome other than the accuracy of his findings. He described the handwriting analysis. He described the ink chemistry. He placed comparison images on the courtroom screen showing the deviation points and the chemical timeline. He stated his conclusions: that the signature on the alleged quitclaim deed exhibited significant characteristics inconsistent with authentic execution by the named grantor, and that the ink chemistry of the signature was inconsistent with the document's stated date of execution by a margin of approximately 4 months. Haynes cross-examined Dr. Tellez for 27 minutes. The cross did not impeach the methodology. It challenged the certainty of the conclusions, and Dr. Tellez acknowledged, with perfect professional composure, that his handwriting findings were probabilistic rather than absolute. His ink chemistry findings, however, he maintained without qualification. The ink did not exist on the date printed on the document. That was not a probability, it was a chemistry. Haynes then presented Valerie's defense. It was brief. He argued that Valerie had acted in her capacity as executor of the estate, and had legitimately understood herself to have authority to convey the property. He argued that the affidavit of heirship, while imperfectly notarized, reflected a genuine and good faith belief on Valerie's part about the ownership structure. He argued that the quitclaim deed, whenever questions existed about its provenance, reflected a genuine intent on my part to relinquish my interest, an intent evidenced by my lengthy absence from the property and my failure to participate in its management. Judge Wren asked one question during Haynes's argument. She asked him to address the legal effect of a quitclaim deed executed prior to the vesting of title. Haynes said that the beneficial interest in the estate should be considered a sufficient property right to support the conveyance. She asked him to cite a case. He cited a case from 1987. She asked him to distinguish it from the facts. He attempted to do so. His argument was that the beneficial interest was a sufficient antecedent interest to support a quitclaim. Her response was that a quitclaim deed is a present conveyance and not a forward conveyance, and that the case he had cited involved a different factual and doctrinal context, and she asked him if he had anything further to add on the legal standard. He said he did not at that time. She said she was prepared to rule. Her ruling was delivered from the bench without recess. She addressed the recorded instruments first. She stated that the chain of title as established by the probate court's order, and the subsequently recorded distribution deeds, was clear and unambiguous. The final order of distribution vested title to 50% of the property in the plaintiff as of its recording date. The distribution deed memorializing that conveyance was recorded and constituted constructive notice to all persons. The affidavit of heirship, she stated, was defective on two independent grounds. First, its content was materially false in that it represented the affiant as the sole heir when the recorded chain of title demonstrated otherwise. And second, its notarization was legally ineffective because the notary's commission had expired 8 months prior to the date of execution. A document notarized by a person without a valid commission is not a properly acknowledged instrument and cannot serve as the legal predicate for a subsequent conveyance. She addressed the quitclaim deed next. She found as a matter of law that even assuming the document's authenticity, a question she declined to resolve as unnecessary, given the following analysis, the instrument was without legal effect as to my recorded interest because it predated the vesting of that interest by 3 months. She cited the principle that a quitclaim deed conveys only such interest as the grantor actually possesses at the time of execution. At the time of the alleged execution, no title had been conveyed to me by the probate court. The beneficial interest in an unadministered estate is not the same as a vested fee interest in real property. The deed could not convey what did not yet exist in the legal form it purported to convey. She ruled that the special warranty deed from Valerie Carver to Dean Property Holdings LLC was void and of no legal effect as to the plaintiff's 50% undivided interest in the property. She entered an order quieting title to that 50% in me. She then addressed the fraud counts. She found that the evidence supported a finding of intentional misrepresentation. The affidavit of heirship's false claim that Valerie was the sole heir, combined with the concealment of my recorded deed from the listing agent and the title company, combined with the full receipt of sale proceeds and their subsequent transfer out of the account, established a pattern consistent with intentional fraudulent conduct. She imposed a constructive trust on 50% of the net sale proceeds attributable to my interest and ordered Valerie to disgorge those proceeds, with prejudgment interest from the date of the wire receipt, to me. She awarded attorney's fees under the applicable statute. She made one additional statement before she concluded. She noted that the forensic evidence regarding the alleged quitclaim deed had not been resolved through the civil proceeding, but that the evidence presented by Dr. Tellez raised questions that she was referring in a written memorandum to the Mecklenburg County District Attorney's Office for their independent review and determination. She made clear that this referral was not a finding of criminal guilt and was not the subject of today's ruling, but that the public interest in the integrity of recorded real property instruments warranted the referral. Haynes asked for a stay pending appeal. She denied it as to the disgorging of proceeds, on the grounds that delay would increase the risk of dissipation. The constructive trust and disgorgement order were immediately effective. We filed certified copies of the order with the Register of Deeds within 90 minutes of the ruling. The lis pendens notation was updated to reflect the court's quiet title determination. The situation with Dean Property Holdings was resolved in a separate negotiation over the following 6 weeks. Because Judge Wren's order voided the deed only as to my 50% interest, the purchaser was left in a complicated position. He had bought the property, paid full market value, and was now in possession of a property to which he held clear title in only half. His title insurance policy with Hargrove Title covered him for the failure of title as to the other half, meaning Hargrove Title was exposed for the value of 50% of the purchase price. Webb, Donahue, and Marsh engaged in intensive negotiations simultaneously with Dean Property Holdings Counsel, with Whitfield on my behalf, and with Hargrove Title's underwriters. The resolution we reached was this: Dean Property Holdings would purchase my 50% interest at fair market value, as determined by an independent appraisal. Since both parties had an interest in resolving the cloud on the title, and he had a legitimate business reason to own the entire property. The appraisal came in at $430,000 for the full property, slightly above the original sale price, reflecting market movement in the intervening months. My 50% interest was therefore valued at $215,000. Hargrove Title contributed a portion of that amount under their title insurance exposure. Dean Property Holdings paid the balance. The transaction closed with a warranty deed from me to Dean Property Holdings, properly executed, properly notarized, properly recorded. The chain of title was now clean. The disgorgement order against Valerie was separately enforced. The constructive trust covered my share of the net proceeds from the original fraudulent sale, approximately $184,000 after accounting for the attorney's fees award. Whitfield filed a judgment lien against her personal property. The investment account had been substantially depleted, but between the remaining balance and the assets available for levy, the collection process was completed over a period of approximately 4 months. I am not going to describe the specifics of that enforcement process in detail, because it is not the most instructive part of this story, but I will say that the mechanisms available to a judgment creditor in North Carolina are extensive and that they worked. The criminal referral from Judge Wren resulted in a grand jury proceeding. I was contacted by the district attorney's office approximately 3 months after the civil ruling and asked to provide a voluntary statement, which I did. The investigation is, as of the time I am telling this story, ongoing, and I am not in a position to discuss it further. The house on Fenwick Drive was sold a second time lawfully to Dean Property Holdings, with proper documentation, after a proper title examination, with both owners who existed on that date represented by their respective attorneys. The new deed is recorded in the Register of Deeds. The chain of title reflects the full history accurately, including the court order voiding the prior instrument. Anyone who pulls that chain of title in the future will see everything in sequence as it happened, because that is what a public record is. I want to say something about what this experience actually taught me, because it is not what most people assume when they hear a story like this. The lesson is not that family will betray you, though that may happen, and it happened here. The lesson is not that greed is corrosive, though it is and it was. The lesson is not even that you should trust the legal system, because trust is a passive orientation, and what served me here was something more active than trust. The lesson is that records are the architecture of accountability. My mother did not leave me that house as a sentimental gesture sealed in private understanding. She left it through a process. The process created documents. The documents were recorded. The recording gave those documents legal weight in a system that was built over centuries of common law to protect the value of recorded instruments against the unilateral actions of anyone, including family members, including executors, including people who believe they are entitled to more than they received. Valerie's plan had worked at every informal level. She had listed the property as the sole owner, and no one at the brokerage had looked deeper. She had filed an affidavit of heirship, and the Register of Deeds had accepted it because the seal was present. She had handed the title company a document that purported to explain away the probate deeds, and the title company had accepted it because they wanted the transaction to close. She had received the wire and moved the money and believed the matter was finished. What she had forgotten was that my deed was in the chain, not in a drawer, not in my memory, not in my claim, in the chain, recorded, indexed by grantor, indexed by parcel, accessible to anyone with a computer and a parcel number. Fixed in the public record on the date it was stamped and filed, before any of this began, before she made any decision, before she contacted any agent or title company or buyer. My ownership of 50% of that property had been established, not by my assertion, but by a court order and a recorded instrument. And those two things have a durability that is entirely independent of whether anyone pays attention to them. She did not forget to hide the deed. There is nothing you can do to hide a recorded deed from a title chain. She forgot that the deed existed as a matter of public fact rather than private knowledge. She treated the situation as a family matter, as an informal arrangement that she had the social authority to manage however she chose, and she failed to account for the fact that public records do not operate in the register of informal family authority. They operate in a different register entirely, one that is indifferent to who believed what, and who intended what, and who was the more assertive sibling, and who was absent from the property for several months. The record shows what it shows, and it shows it to everyone equally. Patricia Holloway's phone call gave me the information I needed to act. Carl Whitfield's expertise and precision gave me the tools to act effectively. Judge Wren's analysis gave me the legal vindication I was entitled to. But the foundation of all of it, the reason any of this worked, was a piece of paper recorded at the Mecklenburg County Register of Deeds, 14 months before a moving truck arrived at 4417 Fenwick Drive. Everything else followed from that. Not from my anger, not from my sense of injustice, not from my willingness to fight for what was mine. From a recording stamp. If you have property records, title documents, or estate instruments in your life, know where they are, know what they say, know the parcel identification numbers and the recording dates, and the names of the courts and the case numbers. Keep certified copies. These documents are not administrative trivia, they are the legal fact of what you own and what you are owed, and unlike conversations and promises and family understandings, they do not depend on anyone's cooperation to remain true. If something in this story resonated with you, if you have experienced a property dispute, a title issue, a situation where records either protected you or failed to protect you because you did not know they existed, I am genuinely interested in hearing about it in the comments. The specifics of real estate law vary considerably from state to state and country to country, and the procedural details I describe here are particular to North Carolina, but the underlying principle, that public records are the architecture of accountability, is universal. If you found value in this story and want to hear more cases examined with the same level of procedural detail, subscribing ensures you will not miss the next one. I do not treat these stories as entertainment. I treat them as case studies in how systems work when you understand how to use them, and how they fail when you do not. The house on Fenwick Drive sold for the second time on a Thursday in March. The closing took 45 minutes. Both parties were represented. Every document was properly executed. The title insurance commitment had no exceptions. The recording stamp on the final deed reads the date I signed it. It is in the chain now, and it will be there for as long as the county keeps records. Which, as far as I can tell, is indefinitely. That is how it ended. Not with a confrontation, not with an apology, not with a conversation over a kitchen table or a courtroom drama in the movie sense. With a recording stamp and a wire transfer and a file folder that Donna from Whitfield's office organized into 2 neat binders and sent to me by courier the following Monday, along with a final invoice and a handwritten note that said, "Records win." She was right. They do.